Next case set for argument is State of Ohio versus Carlos Gonzalez. It's case number 29018. State of Ohio has waived argument in this case, so we will only be hearing from Attorney Rogochevsky on behalf of Mr. Gonzalez. We have read the briefs and are prepared to proceed. If you are, you'll have 15 minutes, of course, for your argument.
Thank you, Your Honor. Good morning.
Morning.
I'm Barbara Rogochevsky, and I'm here on behalf of the appellant Carlos Gonzalez. Criminal Rule 11C states that the court shall not accept a guilty or no contest plea to a felony without addressing the defendant personally and determining that the defendant is pleading voluntarily, that with full understanding of the nature of the charges and the maximum penalty. That understanding of the maximum penalty also includes whether any part of the sentence must be served consecutively to any other part. That is because when a consecutive sentence is mandatory, that directly affects the length of the sentence and consequently the maximum sentence. The case law is very clear on this point, that the defendant must understand the nature of the charges, the potential penalties, including the maximum penalty for each charge and the maximum aggregate penalty, in order to make a knowing, intelligent, and voluntary waiver of their rights and enter into a plea. Because this right is non-constitutional, the court's explanation, or if the court's explanation is imperfect, a substantial compliance rule applies. That is whether the record reflects that the defendant subjectively understands the nature of the penalties, the charges, and the deal that they're entering into. In this case, Carlos Gonzalez pleaded guilty to a number of charges. Probation violation, a number of charges including aggravated assault and trafficking, and then a failure to comply under RC 2921-331, which is a third-degree felony. And under the subsection to which he pled, it also indicates that he's accepting the stipulation that in his actions, he caused a substantial risk of harm. And because of that subsection, and due to the nature of the plea, his sentence for that offense specifically was required to be served consecutively to all the other sentences at the time he was sentenced. He enters his plea, he's sent for a pre-sentence investigation, and then when he is sentenced, he receives 3 years total on all of the sentences other than the failure to comply, including the probation violation, and then 3 years in prison on the failure to comply, consecutive for a total of 6 years. It's our contention that Mr. Gonzalez did not understand the nature of the plea that he was entering into because he did not understand the maximum potential penalty that he would be facing.
Now, I know it's a substantial compliance standard, whether he subjectively understood that in this case he was going to receive a consecutive 3-year sentence for the failure to comply. How does the fact that counsel on the record and in open court indicated to the judge that this does carry a mandatory consecutive sentence, how does that factor in our consideration?
Well, I think you make a very important point. And I think when we go through the plea hearing and go through the transcript itself, here's how that whole plea and what you reference as far as that colloquy, here's how that plays out. And
before you answer, I'd also be interested in knowing whether or not the judge used a written plea form where that was noted, or whether or not it was in the PSI and discussed on the record that counsel reviewed the PSI with his client, and whether or not they made any comments about the consecutive sentences. Not to interrupt you, but if you can hit all those issues, it'll save me from asking a few more questions.
Okay, well, I'll try to do that, and if I forget something, please remind me.
Go ahead.
Okay, so first when we go to I think the plea is what's really the crux of this. Because Criminal Rule 11C specifically focuses on the plea and the colloquy during the plea. So when we look at specifically pages 16 and 17 of the transcript, what we find is prior to that, the court did enter into a colloquy with Mr. Gonzalez. He went over each of the charges and the maximum potential penalty of each individual charge, including the failure to comply, that it could be a maximum of 3 years in prison for that charge. However, once Mr. Gonzalez indicates that he understands the nature of each offense and the potential penalty for each offense, what does not happen is that the judge then advises Mr. Gonzalez that the failure to comply must be served consecutively. That does not happen at all. It is not contained in the transcript, period. Then the judge makes a finding that Mr. Gonzalez understands the nature of the charges, he accepts the plea, and that actually happens on page 16. Then, once we go a little further into page 17, after the court makes that finding, then there's a discussion by the attorneys of the, quote, willful flee. There's mention of it. The, quote, willful flee being a consecutive sentence. And then that's all that's said, and then the hearing is then concluded with a determination that a pre-sentence investigation will be done. So what's interesting also is that you'll find on page 17 that Mr. Gonzalez, during this colloquy with defense counsel, specifically states that he thought that the failure to comply was supposed to be a misdemeanor. So we have an advisement of the potential penalties, no advisement that the failure to comply, it must be served consecutively. Defense counsel mentioning a willful flee, and no indication that Mr. Gonzalez understands willful flee is supposed to actually be the failure to comply. That that's served consecutively. And then Mr. Gonzalez saying after that he thinks that maybe this should have been a misdemeanor. And then the hearing is concluded with referring it for a PSI.
So counsel, you're wanting us to say wasn't knowing, intelligently, voluntarily made plea, so that would mean the plea should be vacated.
That's correct, Your Honor.
And so he's facing like 1 million years in prison now. I mean, he got a 6-year prison bill. And so, I mean, he's got cases galore that were all resolved through this.
He's got a number of cases, a number of charges pending. That is absolutely true. And actually, I believe he's now served close to 3 years of that 6-year sentence, once you factor in his time served prior to his cases being resolved. I believe he spent at least 9 months in jail awaiting trial. And
I'm just thinking about knowing, intelligent, and voluntary. I mean, my gosh, if we vacate this plea, that's, he could be in a world of hurt.
well, Mr. Gonzalez, his charges would be reinstated. Let's just put it that way. And I know he understands that. So back to your original question, Your Honor. I think a plea hearing indicates that he could not have made a knowingly, intelligently, and voluntary wavering plea because there was not substantial compliance. In fact, in the Abernathy case, it specifically states that if the court does not advise the defendant that the sentences must run consecutive, then that cannot be substantial compliance. Now, you had also asked me about pre-sentence investigation and then the plea hearing.
A written plea, whether or not.
I don't know if there was a written plea form off the top. I don't know that that was specifically, I'm sure it's in the transcript of the records, but my argument is it doesn't matter because the colloquy must happen. So even if there was a written plea form, I don't know that that written plea form specifically states that the violation of the failure to comply must be served consecutively. It still must be explained on the record. And that's also the finding that this court made in the State v. Bailey case in 2016. And I think it's important to recall that Mr. Gonzalez's confusion about the level of offense of the failure to comply is really important here. Because in order to make a finding that the trial court substantially complied, there has to be a subjective understanding of the potential penalties and the nature of the charge. And I don't know how we can make anybody can make the finding that he understood if during the hearing he specifically states that he thought one of the charges, which was a felony in the 3rd degree, should have been a misdemeanor, I think that's very disingenuous. And of course, during the heat of the moment in a plea hearing, these things can go very quickly. But I think, with the hindsight and the time that we have to look back on it, I think it's very clear that he did not understand what was happening.
Another question, counsel, was this an agreed sentence?
It was not an agreed sentence. In fact, as we had stated in our brief, the agreement was to plead to certain charges, others would be dismissed, and that the state would cap their recommendation at 7 years. The defendant was free to argue for any sentence, even including community control, because for most of these offenses, community control was a possibility, at least under the sentencing guidelines. And then the court would, of course, sentence in any way that it saw fit, based upon the nature of the charge, any testimony, and then the PSI. So the fact that it was not an agreed sentence only serves to highlight and compound the fact that he may not have truly understood that the maximum potential penalty could have been up to 8.5 years, but that he didn't necessarily understand that whatever the sentence was on the underlying charges, that 3 years for the failure to comply would have to be served consecutive to the remainder of the sentence. Now, the state tried to distinguish the Bailey case and say that Mr. Gonzalez clearly understood the case. But I honestly think that when we look at the Bailey case, in which this court overturned a conviction and vacated a plea with some very similar charges, I think it's almost on point. And any of the differences in that case versus this case actually shade in favor of Mr. Gonzalez. In the Bailey case, there was an underlying community control violation, just as in this case. In the Bailey case, there was also a plea to a failure to comply, an F3 that would have required consecutive sentencing. In our case, there was additional charges as well. Interestingly enough, in the Bailey case, there was also a colloquy by counsel about the consecutive nature of the failure to comply sentence, but there was no specific advisement by the court that failure to comply must be served consecutively. And then, interestingly enough, the prosecutor in the Bailey case mentioned that the sentence for failure to comply would have to be served consecutively. The plea was accepted, and then Mr. Bailey appealed, and this court made a finding that under those circumstances, the plea was not held pursuant to Rule 11C and vacated the convictions and vacated the plea. The facts of that case are almost directly on point with this case, and I think that that case illustrates that we cannot impute an understanding of the case, of the potential consequences and the nature of the case to a defendant based upon the understanding of the attorneys, whether it's the prosecutor stating it on the record or whether it's even defense counsel, as in this case, stating something on the record. Just because the attorneys understand it, even defense counsel doesn't mean the defendant does. And failing to ensure that the defendant understands that, unfortunately, makes this plea defective. I have just a few minutes left if there's any other questions.
So you're saying the transcript in this case, when he discusses the the maximum potential penalties, the judge did not explain to the defendant the mandatory consecutive aspect of the failure to control with injury.
The judge in this case never said to Mr. Gonzalez, if you plead to failure to comply, which is a 3rd-degree felony, any sentence that I impose for that offense must be served consecutively to the sentence of all of the other offenses, regardless of what those sentences are. He did not do that. He discussed the maximum penalty for each charge, including the failure to comply, which would be 3 years, but not that that one would have to be served statutorily with no discretion to the court that it would have to be served consecutively.
Thank you. Any other questions? All right, thank you for appearing this morning and for your argument. We'll take the matter under advisement, issue a decision in due course. You will be mailed a copy of the court's decision by the clerk of courts on the day released and also keeping it secure on Supreme Court of Ohio's website as well. Thank you again for your argument today.
Thank you, Your Honor.